Good afternoon, everyone, and happy Friday. Welcome to today's iteration of the live employment law Q&A by employmentlawyer.ca. My name is Teilen Celentano, and I'm an employment lawyer and associate with Samfiru Tumarkin LLP, and I work out of our Toronto office. As always, please go ahead and ask your questions however you're watching this, whether through Facebook, LinkedIn, Twitter, YouTube, X, and I'll do my best to answer them live. You can also go to our website at employmentlawyer.ca. Email us at help@employmentlawyer.ca or give us a call at 1-855-821-5900. I'd like to start off today by talking about two topics. The first is the news that Chipotle is opening two new stores in the GTA, one in Toronto and one in Markham. So we've talked before about your rights when you're starting a new job. I think that one of the most important things that may not be intuitive to employees is that when they're starting a new job, they actually do have some leverage. Employers have, at that juncture, gone through a whole hiring process, reviewed tons of applications, talked to a number of different potential employees, and have selected that you are the one that they want to hire. So in being that lucky person, you do have some leverage. Sometimes, depending on the position, they will have also told maybe their second and third options no, really, in that case, giving you more leverage. So what should you do? What should you be on the lookout for? So first and foremost, if your employer is asking you to sign a contract, new job here, please sign this contract. It's imperative that you get an employment lawyer to take a look at it and go through it with you to explain what you're agreeing to. There are a number of things in a contract that, while innocuous, may seem innocuous, can have huge implications on someone's long-term employment in their future. The one that I always make sure I'm on the lookout for when I'm reviewing contracts with new employees is temporary layoff clauses. Most people believe that they can be temporarily laid off at the whim of their employer. Some people call it a furlough. However, that's not the reality. As we saw in hundreds and thousands of cases at the beginning of the COVID-19 pandemic, there is no standalone right for employers to place you on a temporary layoff in the common law. And the first time that your employer does that without an express contractual term, so without a written contract saying they can, the first time they do that, that is a constructive dismissal. Now, we talk about constructive dismissals, at least I know I do in every one of these live Q&As, but what a constructive dismissal is it's defined as a substantial change to the terms of your employment that is unilaterally implemented by the employer and not accepted. So the way our courts look at a temporary layoff is if, again, provided there's no contractual term, it's we're not letting you work and we're not going to pay you. That's a huge change because the standard terms are I will show up to work and get paid. And when that happens for the first time in your employment, you're allowed to treat your employment as having been terminated without cause. And then you can pursue severance damages in a full severance package, which, depending on the terms of your employment, can be as much as 24 months. So when looking at these contracts, check to see if there's a temporary layoff clause, because if there is, you lose that ability to trigger constructive dismissal immediately upon being temporarily laid off. Instead, if the employer lays you off, it doesn't give you anything, they can, for a period of up to 13 weeks, so a quarter of the year, 3 months, place you on a temporary layoff without work, no pay. And your only recourse at that point, the only way to make ends meet might be EI, which if you do have enough insurable hours, maxes out at around $600 a week. And if they decide instead to lay you off but continue your health and dental benefits, well, then in that case, you can be on a temporary layoff for up to 35 weeks. So almost 2/3 of the year. So that is something that whenever I'm looking at contracts, I'm making sure that my eye is drawn to that and I'm highlighting that to potential new employees. The second thing is the location of work. Since the pandemic hit, a lot of people have been given the opportunity to work from home. And in fact, some people have been hired. And during the hiring process, during the recruitment process, they were told full-time remote position, you'll never have to come into the office. But then when they get the contract itself, it says is subject to change. You may subject to the employer's decision to recall people. And if that's the case, You accept a job on the basis that it's going to be full-time remote, and that's the lifestyle you want. But you sign a contract that says they can change it. When they do change it, your recourse is limited. Okay. And the last thing I want to mention before moving on to my second topic for today is that most, if not all, contracts have what's called an entire agreement clause. So essentially, they're always worded a little different, but they boil down to this, that the entire agreement between the employee and the employer is contained within the contract, and any other previous discussions are wiped out. So oftentimes people will say, yeah, in the interview process, they promised me this. It's not in the contract, but they told me not to worry about it. If you sign a contract that contains an entire agreement clause, and they almost universally do, then any of those understandings that you had during the hiring process, handshake agreements, nudge, nudge, wink, wink understandings are null and void. So it's really important that everything you talked about, everything you agreed on, everything you're relying on in taking this job is written down ink on paper. And if it's not, then it's as if that never happened. So make sure everything you asked for is in there, but also make sure that you go through it with an employment lawyer who can explain everything in detail and really discuss how the specific contractual terms may affect you in your employment and in your life. The second topic I want to talk about before getting into your questions today is the news that Rogers has laid off employees in their sports and media divisions. So Rogers Telecommunications, obviously a massive company, one of the big two telecom giants in the country. For those of you who don't know, Rogers has a number of sports channels, and they also own the Toronto Blue Jays. So they have announced that they are laying off a number of people, a number of media jobs. So the question is, what happened? So in Canada, you can either be provincially regulated or federally regulated. The vast majority of employees in Canada are provincially regulated and are therefore subject to the laws of their province. There are, however, a few industries that are, by rule, federally regulated. Media, so television, radio being one, and banking is the other big one. But again, there's about a dozen or so. And for federally regulated employees, those who are not managers, so non-managers who are federally regulated, those people can only be laid off in two circumstances: genuine bona fide restructuring or for just cause. They actually cannot be let go without cause. That's a very important distinction. Where provincially regulated employees in Ontario can be let go without cause for a non-discriminatory reason. That isn't the case for federally regulated employees. So if you're one of those Rogers employees who's been let go, one of the important things to figure out is, was it genuine restructuring? Were you laid off? Was your position eliminated due to business needs? Or were you laid off for something else? If the answer is something else, then you actually have an extra tool available to you in an unjust dismissal complaint. Now, one of the important things, though, to note is those unjust dismissal complaints have a very short timeline for you to start a complaint. It's a period measured in weeks rather than years. Normally, to start a lawsuit, you have 2 years to start a lawsuit from the date on which you're let go. It's called the limitations period. And there are ways and reasons why it can be extended, but generally speaking, from the date you're terminated, your employment is terminated, you have 2 years to start a lawsuit. But if you want to start that unjust dismissal complaint, the period of weeks to get it started. So if you're one of those Rogers employees, or you're any employee for that matter, it's imperative that you reach out to us at employmentlawyer.ca to schedule time to speak with one of our legal reps, because you may just run out of time on certain remedies that would otherwise have been available to you. So if you're let go, don't lollygag, don't bide your time. I understand everyone needs to lick their wounds and recover, and that being let go is traumatic, but it's important that you reach out to a lawyer and seek help as quick as you can to make sure that all your rights are being protected. I'm going to jump now into a few questions we have. So the first one is from David on Facebook. He says, I've worked for a company in management since 1996. They were going to be bought recently, but the deal fell through. I sense ownership may just shut it down. I believe I am entitled to 8 weeks of pay, but I am wondering if I should be receiving more. So David, you are entitled to more. So there's a bunch of different ways that employees in Ontario, and I'm going to assume you're provincially regulated in contrast to the Rogers employees I just mentioned, I'm going to assume you're a provincially regulated employee. So in Ontario, you're entitled to severance in two ways. The first is under the Employment Standards Act, or the ESA. The way to view the ESA is it's your floor. It's the bare minimum severance you're entitled to. So under the ESA, you're right, you're entitled to 1 week per year of service up to a maximum of 8 of termination pay. And that can be provided to you as notice. So David, we're closing in 8 weeks and your employment will be terminated effective that date. Or it can be given to you by way of pay in lieu of notice. So you're being let go today, David, here's 8 weeks pay. The second way under the Employment Standards Act that you're entitled to severance is to ESA severance pay. It's separate and distinct, and it must be provided as payment, and it cannot be provided as notice. In the way to be entitled to ESA severance, two preconditions need to be met. First, you've had to have worked for the company for longer than 5 years. In your case, you've been there for 28, pushing 29 years, so that's no problem. And the second is the company has to have a payroll in excess of $2.5 million. Now, that's obviously a lot of money, $2.5 million on an annual basis, but it's not necessarily as high as some people think. The simple math is that if you have 50 people working, making on average $50,000, the company has a payroll in excess of $2.5 million. So there are actually pretty small businesses that can hit that threshold pretty quickly. So if the company has a payroll over $2.5 million, David, then your bare minimum entitlements are those 8 weeks of termination pay and those 26 weeks of severance pay for a total of 34. But in addition to that, you also have enhanced entitlements under what's called the common law. Canada, the United States, England, Australia, all common law jurisdictions. And what that means, broadly speaking, is that lawyers and courts rely on previous cases in order to determine what is fair in present cases. And in Canadian common law, what you're entitled to way more than your minimum entitlements under the ESA. Instead, you're entitled to pay in lieu of notice, which can be as much as 24 to 28 months, depending on the terms of your employment. Those terms and those conditions, the thing our courts look at are your age, your length of service, and your availability of similar employment. So I'll speak about each of those pretty briefly. So the first, your age. It's not that the court is trying to say anything about people's age, but what they have recognized is that younger people who grew up with computers, people who know how to look for jobs online, they have an easier time finding new work. So generally speaking, people's in their 20s and 30s, they get awarded a little less severance because, again, our courts say it's easier for you to find new work. You don't need it. People in their mid 60s, 70s, and 80s, our courts say, have a more difficult time finding new work for the exact opposite reasons I just mentioned. Maybe they aren't as familiar with computers. They're deemed to be not as fast when they work. Potential employers may be worried that the person will only work for them for a short period of time. So all those things make it harder for people in the later stages of their careers to find new work. So people, like I said, 60s, 70s, 80s, they get awarded a little more severance. And then people in their 40s and 50s, they're mid-career, they're more or less considered the baseline. The second thing our courts look at is length of service. So if you're a short service employee, you're still entitled to severance. But someone who's been there for 10, 15, 20, almost 30 years like yourself, David, you would be entitled to more severance because the courts would say you haven't looked for work in a while, and someone a future employer may be afraid to hire you because you're so used to working at one company, and that search for new employment will take you longer. And then lastly, the availability of similar employment. This is kind of the catch-all for everything else. So our courts will look at things like, how much money did you make? If you made a lot of money, our courts recognize that jobs that pay $1 million a year are much harder to find than jobs that pay you minimum wage. Also, what industry are you in? Are you in an industry that is very niche and very small and there are very few employers? Or are you in an industry where there are tons of jobs and tons of available jobs that you could easily slide into? Also, other things that might affect your ability to look for work. Do you have a disability that needs to be accommodated? Is it a visible disability that would inherently make finding a new job more difficult? Is it is English your first language? Our courts have taken notice of the fact that people who are non-native speakers of English or French have a more difficult time finding new work in Canada than people who are native speakers. And then once the courts look at all those factors, they try to ascertain really how long they think it will take you to find that new job, that new comparable job. It's not any job. Nobody would expect you to go from making $100,000, $200,000 a year to making minimum wage, nor would someone expect you to go from a senior management position to an entry-level position. The court always says, how long will it take for you to find comparable employment? And again, that can be as much as 24 months. And with extenuating circumstances, we've seen recently 26 and 28-month awards as well. But so David, I guess to answer your question shortly, yes, you likely should be receiving more than 8 weeks. Don't sign anything before speaking to one of our lawyers, and you can set up a time to talk with one of us at employmentlawyer.ca or emailing us at help@employmentlawyer.ca. A question on Facebook from Clayton. Are short-term and long-term contractors entitled to severance? So the term contractor, Clayton, is a term of art, right? So it's a legal term of art. And the word contractor is oftentimes what it means to be a contractor, something that's oftentimes litigated in my career and in the employment law bar in general. So generally speaking, if someone is a true independent contractor, no, they're not entitled to severance. But the reality is that there are tons of people in this province that are wrongfully classified as contractors or consultants and are therefore deprived of their protections under the Employment Standards Act and deprived of severance. So whenever we have someone who comes in who's been classified, who's been paid as a contractor, we really look at their case through a two-part analysis. The first question is, are they actually a contractor or are they an employee? And to look at that, to make that determination, our courts look at a number of things. The first and the most heaviest part or thing considered is control. Who exercises, what is the degree of control exercised over the worker, right? So is the employer, is the company, they telling this person when they have to show up? Are they telling them what they have to do? Are they telling them what they have to wear? Are they telling them how they have to work it? Are they prescribing certain systems? Are they making these contractors beholden to a code of conduct? And the more control that employer exercises, the more likely that person is deemed to be an employee. The second thing that our courts look at is ownership of tools. So who owns the products necessary to do the work? Think, for example, if you're hiring a plumber, the business is hiring a plumber to come in and fix their toilet. My business, my law firm, it's unlikely that we have all the tools necessary for the plumber to fix the toilet. So in that case, the plumber would own the tools, indicating that they're likely a contractor. Versus if you work for a company, say you work a desk job for a company, they're providing you the laptop and they're providing you the office space and they're paying for the operating system and the email accounts and the cybersecurity systems. Well, then that indicates that you're more likely to be an employee. The next thing our courts look at is chance of profit or risk of loss. So if you go in and you're paid an hourly rate, you show up, you get paid $20 an hour. If you work 4 hours, you get $80, so on and so forth. Well, then in that case, there is no chance of profit for you, right? If you may be able to work more hours, but that's not a profit. That's not an advantage. Similarly, commissions aren't viewed to be a chance of profit. What a profit is a windfall. It's something that you get paid for in excess of what you do, and in excess for more than just your hours or more than just the things you sell. Think of someone who has an equity stake in the business who maybe gets the value of their assets, the value of that business goes up the better they do. That's a chance of profit. And similarly, a risk of loss by the same token is you actually could lose something even if you go in and do a good job. And if there's no chance of profit, if there's no risk of loss, it's likely that that person is not a contractor and instead an employee. And then the last thing our courts look at is what's called the organizational test. Some people call it the integration test. Generally, what our courts say is whose business is it? Are you in business for yourself or are you in business for the company, right? Going back to the example I used earlier with a plumber at my law firm, if the plumber comes in and they fix the toilet, obviously we need plumbers. Obviously we need working toilets and they serves a useful role, but providing bathrooms isn't a core tenet of our business. Versus if we had, someone come in to provide legal services at a law firm, that's a core tenet of our business. They're in business for us. So our courts, again, they look at what you're doing. If the work you're doing is core to the business, it's more likely that you're an employee. And if it's not, then more likely you're a contractor. So if we go through that and we say, okay, Clayton, we think you're an employee, then you're entitled to severance. But if we go through that and we say, okay, maybe we think you're still a contractor, that doesn't mean you have no severance entitlement when you're let go. Our courts have recognized that there's an in-between category between employees and contractors, and they call that a dependent contractor. And our courts have said that the hallmark, what the hallmark for what makes someone dependent is financial dependency. And importantly, you don't need 100% dependence in order to be viewed as a dependent contractor. There is no floor. There's no bright line where it says, this much percent of your earnings have to come from one company in order for you to be dependent. It is determined on a case-by-case basis, but generally, it's more than 60% is generally the rule. And if you earn more than, you earn a substantial portion of your earnings from one company and they let you go, then as a dependent contractor, you're still entitled to severance. You're entitled to severance in the same quantums and the same amounts as if you're an employee. So, Clayton, to answer your question, are short and long-term contractors entitled to severance? Yes, if they are dependent contractors. They may also be entitled to severance because they've been wrongly classified as contractors. And when you're wrongly classified, in addition to losing that severance entitlement, you've also lost out on other entitlements: vacation pay, public holiday pay. Certain job protected leaves are also not given to contractors that are given to employees. And if you have been wrongly classified, then I'd suggest you reach out to us at employmentlawyer.ca, schedule time to speak with us to see if one of our employment lawyers can help you go after your earned but unpaid vacation pay from years past. I've got a question on YouTube from Sab. My employer offers benefits after a 6-month probationary period. My probation period has ended and they still have not activated my benefits. When speaking to colleagues, I found this is a common issue. Some employees have been waiting over a year and still nothing. What can I do to get them to activate my benefits? So Sab, the first question is, where does that, is that something that they said during the job interview process, or is that something that was written in a contract? It's something that's written in a contract, right? And it says after 6 months, we will give you benefits. That's enforceable. We can force the company to comply with that. That's just something they said in a hiring process or in discussing, in the onboarding process. That can be more difficult. In your case, Sab, I think the first thing I'd suggest you do is reach out to your employer and ask how you want to. And in doing so, you probably don't want to be too confrontational because you still work there. And aside from this, it sounds like you enjoy working there. So what I would recommend that you do is that you just ask them about the benefits and then follow up via email. And when you follow up, say something, it's not meant to be confrontational. It's just, hey, further to our discussion, my contract says this. When can I expect my benefits to be reinstated? And hopefully that little kick in the butt is enough to get them to go to start your benefits and give you the coverage. But if it's not the case, and it is something that's written in a contract, then your best course of action before doing anything beyond that would be reaching out to one of our lawyers and speaking with them to find out how we can help get that for you. There may be ways we could, either ghostwrite things for you or send a formal letter to your employer asking for that. And there's a bunch of different ways we can be creative. But beyond just asking your employer and sending a quick email, there are quite a few landmines that you could step on that could really impact your entitlements if things go awry. So if that first email doesn't go the way you want it to, then I'd recommend reaching out to us, emailing us at help@employmentlawyer.ca so that one of our lawyers can walk through the situation and talk to you about your rights and what next steps could be. Question on YouTube from Fonz, excuse me. My job is seasonal from spring to fall. This year was my 4th year returning to it. Each year we sign an offer letter. In previous years, we always worked 40 hours, rain or shine. This year, without notice, they decided to start sending us home without pay on rain days, something that has never been done before. Can they do this? So, Fonz, it depends on what the contract says, whether the contract gives prior notice or gives credit to past years. Generally speaking, when you show up to work, any day you show up to work, if the company sends you home, they have to pay you for at least 3 hours. It's called the 3-hour rule. It's a provision of the Employment Standards Act, which again is a bare minimum legislation. So if you go to work and after an hour it starts raining and they want to send you home, at bare minimum, they have to pay you for 3 hours, even though you weren't there. The second thing is that this does sound like a significant change, right? Depending on how much it rains in a given year, it could result in a substantial reduction to your rate of pay. And in those situations, like I said earlier, a substantial change to the terms of your employment can result in a constructive dismissal. Now, the big question is substantial. Is it substantial? And that always just comes down to money. Does this change represent enough of a reduction in pay that a court would say you're no longer bound by the terms of that employment? Without talking to you, without actually seeing the impact of how many rain days you had and how much it reduced your pay, it's difficult for me to say. But if it rained enough and you lost enough money, then it could be a constructive dismissal. So the next question is, what do you do? How can you resolve that? So it's important to immediately object to any change when it happens, as it happens. What our courts have said is that if there is a substantial change to the terms of your employment and you accept that change or you acquiesce to that change, then that's now a new implied term. So Fonz, if this happened, your job is spring to fall. So if this is something that got changed in March, April, May, and continued throughout this year, and you're only now raising it as an issue, there could be a danger that a court would rule that you've acquiesced to this change, and therefore can't pursue a constructive dismissal at that point. So I think really it's important for you, Fonz, to reach out to us, employmentlawyer.ca, email help@employmentlawyer.ca. So you can talk with one of our lawyers who can talk you through what your rights are. I think you should do that before bringing this up with your boss or taking any other actions. So last question for today. Question from Julie. I've been at the same job since 2020. I've been on a medical leave since December of 2023. I'm returning to work this December and I fear they are going to lay me off when I return. Can they do that? Short answer, Julie, is no. Under the Employment Standards Act, people are entitled to a number of different job protected leaves. Medical leave is one of them. Family responsibility leave is another. Reservist leave, paternity, maternity, parental leave. Those are all job protected leaves. When you go on one of them, your employer has a few obligations. First, they have to let you take it. They can't deny you a maternity leave or a medical leave if you require it. The second is that when you are ready to return, they must return you to the same job if it exists, and if not, to a comparable one. So if when they return, they lay you off, Julie, then they are breaching the ESA or likely breaching the Human Rights Code. And you're not only entitled to severance in such a case, but you'd also likely be entitled to additional damages. But that's all I have. That's all the time I have for today. So thank you all very much for joining us. Again, my name is Teilen Celentano. This was a live employment law Q&A. Please join us for our next one on Monday, this coming Monday at 1:30 Mountain Time with my colleague, Luke Serta. I hope you all have a great Friday, and we'll see you soon. Bye-bye.